So, welcome to this webinar from Shropshire Partners in Care on mental capacity. Today's subject is going to be lasting powers of attorney and court-appointed deputies, and we are joined today by Lorraine Currie, who is an independent mental capacity consultant. So, without further ado, I'm going to hand over to you, Lorraine.
Thank you, Karen. You made reference to no coughing on the recording. Well, I'm just going to hope that I get to the end of the recording because I have got a strange voice today. Anyway, welcome. The first bit, as Karen's already hinted, is kind of going to be just me going through the details. It's quite a dry subject to try and make it more exciting, but hopefully you will get the information that you need. The best bit really is when we stop the recording and then we can have questions and talk about how this applies, challenges that you've had and so on. That's where it gets more interesting really, when we can talk to each other. Okay, so if I'd have had the skills, I would have had, as you can see, there's probably a song playing in your mind there, but I didn't have the time or the mental energy to try and get a soundtrack that said money, 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 but you know, it's there in my mind anyway, and it's probably in yours. Okay, so fundamentally what we're going to be talking about when we're talking about lasting powers of attorney and court-appointed deputy, sorry, the type is a little bit small there, but I hope you can see it. We're really looking at other forms of decision making. So we're starting off really with the question, who can make my decisions? And the first port of call, really, the first rung of the ladder is me. You know, ideally, I make my own decisions. And that's what we would like for everyone else, that they make their own decisions. And then people might need some support to do that. And that's okay. We can provide support so that people can make their own decisions, whether they are financial or whether they are to do with their health and welfare. Sometimes that isn't possible. And the next best option really is a lasting power of attorney. And the reason that I say it's the next best option is because the person themselves will have chosen who to give that authority to. So they will have selected someone. So in a way, it's the next best thing to them making their own decision, because they've selected and given that person the authority that they want them to have. And then if that isn't possible, if a person hasn't appointed someone to make decisions and they lose mental capacity to do so, in some circumstances, a deputy can be appointed by the court. So predominantly in your roles, you're asking, okay, can the person make this decision? If not, is there anyone else who can? Is that somebody with a lasting power of attorney? Is it a court-appointed deputy? And if not, we come to the final option really in the Mental Capacity Act, which is the best interest decision maker. And we've talked before about mental capacity and best interest. So today we won't be saying much about that other than putting it in the context of what an attorney can do and what a deputy can do. Okay, so that's the sort of ladder of decision making, if you like. So we're going to look at options when somebody needs help with one of those two areas, either with their finances or with health and welfare. And there is a difference, and the difference depends on whether the person has mental capacity. So we've got, as I've already said, we've got the concept of supported decision making. So that's where you would support someone, help them to understand what their bills are, what their outgoings are, what their finances might be, or help them to understand the care and support they need, provide practical help with that. There are some times where the Mental Capacity Act allows us to do things for another person. So things that we think of as day-to-day decisions. So somebody might ask you to go for a loaf of bread. You know, you wouldn't feel that you needed to be a court-appointed deputy or have an LPA before you could go and get them a loaf of bread from the shop. Or day-to-day, decisions that we carry out all the time in social care, those everyday care decisions. And then we've got these more formal options of lasting power of attorney, appointeeship, which I will mention in passing, and deputyship. And the key to which one of those it is, it keeps moving onto the other screen, is mental capacity. Mental capacity operates as this kind of dividing line. So with mental capacity, as with any other area, really, that we concern ourselves with or that we've already talked about in previous webinars, with mental capacity, it's your decision. So that is really a dividing line for everything that we're going to be talking about today. So with mental capacity, we've got some options, which is our own decision making, supported decision making, and lasting power of attorney for finance. So lasting power of attorney for finance is slightly different in that you can use that whilst the person has mental capacity with their agreement, of course. So it might be that somebody is going out of the country and needs their finances to be dealt with, so they can make a lasting power of attorney, and it can be used before the person loses capacity as well as when they lose capacity. Whereas a person with incapacity, it's a lasting power of attorney for both finance and health and welfare, deputyship for finance and health and welfare, appointeeship for welfare benefits only, and best interest decision making. So all of those on the right of the slide are available to us in different times and different ways once the person has lost capacity for the specific decision that we're concerned about. Okay. So I hope these don't look as small to you as they look to me. I think because I'm just looking on a small screen, it looks small. That's good. So appointeeship is a sort of a slight anomaly, really. But this is a way of dealing with social security benefits, welfare benefits. It's when the person can't manage their own affairs. And the way they describe it is slightly, slightly different, but they talk about a person being mentally incapable or severely disabled. There can only be one appointee per person, and it can be an individual or a friend, or it can be an organisation. So you often find the local authority acting as appointee for someone. You may find a solicitor, or it may be a family member. And it is purely to deal with welfare benefits. If the person's got more money available to them, then this isn't really a route. But it's interesting how similar some of the requirements are, even though they don't quite use the same language. It's very close. The appointee has got responsibilities, that is to make and maintain benefit claims. It's their job to sign the form. It's their job to do things that you would expect the claimant to do. So to tell the benefit office about changes, to spend the benefit in the person's best interests, and obviously to tell the benefit office if they no longer want to be the appointee. And if a benefit is overpaid, it's going to most likely be the appointee who is held responsible. So it is quite a responsible role. What they do is they carry out a visit. So once you've alerted the benefit office, they carry out an independent assessment of the person's ability to manage their finances, to understand how to make and manage a claim. They have to do some, I don't know what training they get, I'd love to know, but they have to do some assessment about whether the customer, as they describe them, shows understanding of the rights and responsibilities in making and managing a benefit claim. They have to visit at a time that best suits the person, and they should give the person every opportunity to show whether they are capable of managing their affairs. So it's sort of like a mental capacity assessment, really. This is the guidance that they're given. They're told that their visit is to assess the person's capabilities, and they should start with what we would call an assumption of capacity. So they should start by assuming that the person's capable until they demonstrate otherwise. And they focus on things like, can the person pay the bills? Do they know what income they have? Do they have a general understanding of their benefits, how to claim, how to report a change? Do they have a general understanding of the consequences of not reporting something? And can they understand and weigh up information relevant to managing their decisions? So, as I say, it's familiar language to us. It's a lot like we would describe a mental capacity assessment. They're told that it might be helpful to have an independent person present at the interview, so a family member or a social worker. They're told if the person lives in a residential care home or nursing home, do not assume that they are incapable, which would quite like that guidance. If they've lost their ability to communicate, do not assume they're incapable, and make every effort to find out the person's wishes and views by all possible means. So I don't know if anybody's been through this, but I remember going through this when I became appointee for my daughter, and it was just like a little friendly chat sitting around the kitchen table, you know, not anything really in depth. My overriding memory is that it was an older chap, and he just looked like a turtle. And sadly, that's all that I remember. He had this sort of very turtle-like look, and he asked us a couple of nice questions, and he went, you know, and I thought that's not very in-depth, really. But it is quite a responsible position, but it's also relatively easy to become appointee for someone. So you probably have encountered that. I'm sure you will have people who have an appointee, and it may be the local authority, and it may be a family member. Okay, no cost attributed to doing that either. So let's look at our next option, which is lasting power of attorney. And if we weren't recording, I might ask you to put your hand up and ask how many have made a lasting power of attorney for themselves, but we'll do that at the end, because it's really, really important that what we're talking about is not just for those people who we provide care to, but it's for ourselves. It's thinking about, who do you want to make decisions for you when you can't make them for yourself? And given that we never know when that might happen, then why are we delaying? We just need to do it. I'm talking to myself as well as anybody else, because I keep sitting down and printing off these forms and saying to my husband, we must do this. So you complete forms. They are online, and there's very good guidance online. And at the end of the slides, I've put lots of links to different kinds of guidance, some short films and videos and things like that. The cost of an LPA is £82. That's for finance. So if you made both, it would be £164, finance and health and welfare. For finance, you can choose whether attorneys can act as soon as it's registered, as I said earlier, or only even when the person lacks mental capacity. LPA isn't only for homeowners or people who have a lot of money. If it's hard to manage bank accounts or bills, then somebody may choose to have help with that. You can appoint different attorneys for different things. So you can appoint someone as attorney for finance and a different person or persons for health and welfare. which gives you that, you know, not everybody's good at everything. You might have someone close to you who's really good with money, and you might have someone else close to you who really knows what your wishes would be if you were in a position where you couldn't express those wishes yourself. And as I say, we never know when this might apply. Oops, sorry. So if you go online, you will see this. These aren't links. This is just a copy of the slide. But if you go to .gov.uk, everything is there for you to make the LPA. And it is really very simple to do. It's not intended that you need a solicitor to do this. And as soon as you put into Google LPA, it will try to take you to various solicitors who can do this. But the aim of the LPA system, if you like, is that it can be completed very, very easily. I did this recently with my dad, and just put little pencil marks where he had to take it to his GP, or the bits he had to get witnessed. And it was really very straightforward to do, and came back quite easily. So a property and financial affairs attorney can make decisions around things like money, tax and bills, bank and building society accounts, property and investments, pensions and benefits, really anything in that whole region of finances. They can use the donor's money to look after their home and buy things they need. So whether that is the more day-to-day things, but also those big things like we need a new roof, you know, those kinds of things. They can discuss decisions that affect the person's living arrangements and their care with the health and welfare attorney, if there is one. Good question. So because that's popped up, I'll just deal with it. So that's a question about what's the difference between an enduring power of attorney and a lasting power of attorney. So enduring power of attorney is kind of what's the word I'm looking for? It's the early version of a lasting power of attorney. An enduring power of attorney is only about finances. So that's what we always used to have in the past. And if someone's got that, it still obviously continues to be valid, but it's only about finances. So in many ways, there's no difference between an EPA, an enduring power of attorney, and a financial LPA. It just didn't used to be possible to make one around health and welfare, and it now is. So in many ways, no difference between an EPA and an LPA for finance. So if the person holds an LPA for finance, they can talk about the person's care needs, but they are not the decision maker around the person's care needs. But because they may need to pay for those care needs, obviously you can imagine that a conversation is needed. Sometimes, not always. So they have to follow some financial requirements. They have to keep the donors. The donor is the person who's made out the LPA and given it to somebody else. They're called the donee, but we tend to refer to them as the attorney, or we often call them the LPA, whereas it's the bit of paper actually that's the LPA. So they're supposed to keep the person's finances separate from theirs unless they already had a joint bank account or a home together. And unless there's anything in the document to say otherwise, they can spend money on gifts to friends and family members or donations to charity. But as soon as it sort of starts to go big, then there would need to be an application to the Court of Protection. So if they want to do things like pay somebody's university fees or let someone live in the person's house without paying a market rent or give an interest-free loan, as soon as it starts to feel like it's sort of getting into a bigger decision, as you can imagine, I think really then the court has got to approve that spending. So I've tried to put in a couple of little examples. So Joan is living with dementia. She's supported at home by her daughter Brenda and Brenda's 3 adult children. 5 years ago, Joan completed an LPA for finances because she was struggling to get out to the bank and the local shops, and Brenda took on this role for her. As the dementia has progressed, Brenda has needed to use the LPA more often because Joan gets confused about whether she's paid bills or not. It's Brenda's daughter's 21st, and she knows that Joan always bought nice presents for her grandchildren. Joan has got ample money in the bank to give a gift. She discusses the gift with Joan, but finds that she's forgotten almost immediately and is confusing the granddaughter with Brenda. So Brenda decides as LPA, as the attorney, that it's okay to give a gift of £100. So it's proportionate to the amount of money that Joan has got in the bank. It's in line with the kind of spending that Joan will have always done in the past. So Brenda is able to make that decision. Very similar process to make an LPA for health and welfare. Again, the pack is online, and again, the cost is £82. So this is the way that you can be certain that should anything happen to you, then the person that you want to make decisions can make decisions. And there's been lots of examples and lots of case law where people have thought that this would be the case and it isn't. So there are cases that come to mind like Briggs versus Briggs, which was a husband and a wife, and Mr. Briggs had a terrible accident and resulting brain injury. And his wife thought that as his wife, she would be the one who would be able to make decisions. This was a case that ultimately ended up in the Court of Protection about withdrawing ongoing life support treatment. But it was one of those moments where you would just assume, well, I'm the closest person. I won't use the term next of kin because it has no meaning. But in your mind, you might think, well, it's going to be me. If anything happens to my partner or my adult child, then I would be that person to decide. But without an LPA for health and welfare, you can't have the same certainty. You would certainly be involved in the best interest decision-making process, but an LPA makes it certain that you are the decision maker for that person. So it's really something that every one of us, certainly those of us working in care, because we know more than anybody else what it can be like when decisions are taken out of our hands. So we, more than anybody else, really should make sure that we have made an LPA. Oh dear, press the wrong button. Let me try and get back. I've made my screen really small, Karen. What have I pressed? Nope. Okay. Somewhere I should have a maximize button, but I'm not going to press it because I might make it go even worse. Is it still okay for everyone else, that screen? Sorry, I know we're recording. I'll just carry on and hope that everything's okay. Me and buttons don't go together very well. Okay. So health and welfare LPA, that was me giving you all a lecture, and as a consequence I've pressed the wrong button. Health and welfare LPA can only be used when the person lacks mental capacity for the specific decision, and it must be registered. It makes sense to register it at the time it's made, and then it is applicable when the person lacks mental capacity for the specific decisions. You can give or refuse consent to treatment then, in line with the detail that is in the LPA. The person who is the attorney must show the document to care and health staff. And I know this is where we often have lots of issues with people who will say that they have an LPA and they don't show it. So we don't know what it is or which LPA they've actually got and whether it's registered and so on. And as I said, I recently made, my dad recently made an LPA, and when the paperwork came back, I was incredibly confused about what was the original document. And I think, well, you should know about this stuff, Lorraine. But actually, I could find a document that said it's registered, but on it, it says this is not to be used in place of the lasting power of attorney. This is just evidence of registration. So what I realised was they actually send back the form in the full form, but it's got across the bottom in like little dotted bits, validated OPG. And on it, it's got a stamp which says Office of the Public Guardian, and it says this box was blank when registered. I've taken photos of mine, actually, not with any detail on, which I intended to put in the presentation, but I forgot. Maybe I'll add them to the slides and send them along at the end, because it really is quite useful to know what you're looking for. So if you are appointed as an attorney for health and welfare, then you can make decisions, but you still must act in the person's best interests. You cannot make all decisions. So, for example, if there's an advanced decision to refuse treatment, then you would be required to go along with what the person had expressed as their wishes. Ah, there we are. I've got it back, full screen. Yes, sorry. Doesn't look very good, does it, when I'm being recorded and I don't know which button to press. I'm much more familiar with Teams than Zoom. Okay, so if there's an advanced decision saying that the person doesn't want this or that treatment, then as the attorney, you would be obliged to follow that person's wishes. There may be times when you would still need to apply to court. So if there's a dispute, for example, between what the lasting power of attorney says or the person's advanced decision to refuse treatment, or the medical team and friends and family disagree about treatment. So where you get into that arena where the medical team's saying one thing, the person with the power of attorney is saying, but this is the person's wishes, and there's this sense of dispute, then there would need to be an application to court. So as health and welfare attorney, you can only make decisions when the donor does not have mental capacity to make them. So again, as obvious as it sounds, it's another area where you can't have somebody saying to you, well, I'm the LPA and I want this to happen or that to happen, unless there is a consensus really that the person does not have capacity for the decision. So each decision that the attorney steps in to make, they must know that the person does not have mental capacity to make that. And they have to tell people who are involved in the donor's care when they start making decisions. So you may need to then, as I've said, show the document and prove to people that you are now acting for the donor, for the person. Let's have a look at an example. So we've got an example here of Frank, who created an LPA for health and welfare after he watched a TV programme about decision making. Frank has full mental capacity, so this isn't needed yet. Subsequently, Frank had a stroke, which meant that he lacked mental capacity in some areas of his life, most importantly around care and health decisions. A social worker has assessed Frank to need a care package at home. The social worker involves Frank in every discussion, but knows that it is the attorney who will make the decision about the care package. So by the point that we know Frank's had a stroke, which has affected his decision making in some areas. He's determined to no longer have mental capacity around care and health decisions. So the decision maker is the attorney, the person with the LPA. So although the social worker will still do their Care Act assessment, will still develop a care plan, will still propose that care plan and what the care and support will look like, the decision maker will be the person who now holds the LPA. Okay, so that is lasting power of attorney. So we've got appointeeship, benefits only, relatively simple to get, mostly the same principles of incapacity. But also for some people who are so severely physically disabled that they simply cannot do those things that are needed to deal with their benefit claim. Then we've got LPA, health and welfare, finance, which at the end of this session, you will all go online and you will all make an LPA around what your wishes are going to be for the future, around your finances and around your health and welfare decisions. So then we come to the third option. 1, 2, 3, third. And this really is where there are ongoing decisions, but the person already has lost capacity by the time we know that this is needed. So not everyone is going to need a deputyship. It's more likely in financial situations than it is for care, health and welfare. So it depends on their individual circumstances. It depends on whether there are likely to be a large number of ongoing decisions. It depends whether it's for property and affairs or personal welfare. Personal welfare deputy is less common, and it's usually where there's some doubt about whether decisions will be made in the person's best interests. So again, application to be a deputy is all of the forms can be found online. All of these are on .gov.uk. So there's an application form, there's an assessment of capacity, there's a deputy's declaration, there's various other supporting information forms. There's also content which takes you through all of the detail that you need in order to do it. So let's have a look when you might need this. So we've got Thomas, had a serious brain injury at age 17. Initially, he's cared for in hospital, but after a year, he comes home. He's now turned 18, but no longer has mental capacity to appoint an attorney. You have to be 18. I didn't say that. I'll put it on the slides. You have to be 18 to make an LPA. So obviously this is a 17-year-old young man who hadn't thought about making an LPA, but had an accident, has now turned 18 and no longer has mental capacity to appoint an attorney. So this means that he now needs a finance deputy, and his parents also want to be appointed as health and welfare deputy. The finance deputy is appointed first and a specialist solicitor is chosen. Then the parents apply for deputyship, and they explain that they've had to fight on several occasions already to make sure that decisions are made in his best interests. They explain that there are likely to be a series of decisions to be made and that this will be better and more straightforward if they are appointed as deputy, and the order is made. So this is a court order. So we've still got this split. We've got the dividing line around mental capacity. With mental capacity, you decide. With mental capacity, you select someone to be your attorney in the future, which is a second way of making sure that your wishes are carried out. But if you lack capacity, then the option available is deputyship. You probably encounter deputyship with finance, where the council acts as deputy or a solicitor acts as deputy. And there are quite a few health and welfare deputies now, but as I say, it's just not as common. So we're asking, really, when we're looking at this dividing line, we're asking the same things that we ask in any other area of decision making. We're asking, is the person able to make their own decision? If not, we're asking, do they have an impairment or a disturbance in the functioning of the mind or brain? And if they do, is that impairment the reason they cannot make the decision? So we're still looking at the same test of mental capacity that we would look at for any other decision. So whether it's to look at someone's ability to make an LPA, or to demonstrate that somebody lacks capacity in order for a deputyship order, it's the same set of questions that we're used to. But these are sort of quite big decisions, aren't they? And I think what we're doing is transferring decision-making authority to someone else. So it's a huge step. The consequences are huge for the person. If we imagine what that's like to have control of our spending or care decisions being taken away, there's no easy halfway house. One of the things that I started to do quite a lot of work on before COVID, but it hasn't really been picked up since, is the idea of a halfway house bank account, where somebody can actually, in the way that there are accounts for children, I've forgotten the name, but it's advertised on the TV, these sort of cartoony character, where a child has a bank card, but there's actually an adult with kind of overarching control over that, whether there is some way of having a supported bank account, because I'm sure you know as well as I do, it gets very, very difficult when you're trying to support somebody with something like banking. It's very much like a cliff edge. You can either do it all or you can do none of it. So we will, and we are, when we pick it up, it's certainly the National Mental Capacity Forum, we're starting to do work on that, trying to work with banks to see if we can look at a supported bank account. Until that time, supported decision-making is really, really important. People can often do a lot of their own financial decision-making with support. There are lots of different ways, supporting someone with online banking, supporting someone to use a banking app quite safely and in a straightforward way, using very good visual, pictorial prompts to help them understand finances. I've seen too many mental capacity assessments for finance where people couldn't answer questions because no one had given them that information. So it's no use to kind of come charging in and say, oh, they don't know how much the pension is and they don't know what the bills are. My question is always, well, has someone told them? Do they know that information? Where's your evidence that they've been given all of the information that they need? Not conflating capacity and competence is another kind of big thing to avoid. We have a lot of young people who kind of suddenly turn 16 and we're looking at the Mental Capacity Act, or suddenly turn 18 and they've never had any experience of managing money. And it's just too easy to say that they lack capacity in that area and give that authority to someone else without the work being done to support them with finances. And there are one or two good publications out there to support young people with financial decision making. And it's really important to do that before we kind of merge their just general competence and take it to mean that they lack capacity. Avoiding value judgments is another big one. You know, what someone chooses to spend their money on might not be what we choose to spend our money on. That doesn't mean that they necessarily lack mental capacity. It might simply mean that their values are different than our values. They might want to spend money on gambling, or they might want to spend more than we would on clothes. And the best example I had that I'll tell you about, whether it's being recorded or not, was what I call the sausage roll example. And this was real. I read this in a capacity assessment where a young man had bought a tracksuit, and it was way more than the social worker thought he should have spent. Sorry, I'll have to have a drink. And she used this as evidence that he lacked capacity to understand, because he ran for the bus, and when he ran for the bus, he dropped his sausage roll in his bag, and the grease came off his sausage roll onto his tracksuit. And she used that as an example that he was not able to use and weigh the information about how much that tracksuit had costed. I mean, it was a stretch, you know, but it was a good example of not making a value judgment. He might have spent £150 on a tracksuit. I'm sure there are some people who might spend, I don't know, Elton John, what would he spend on a tracksuit? Whereas maybe someone else would spend £15. It's different. It's about value judgments. And the same thing is true about confirmation bias. You know, we might decide to support someone to make their own decisions, and then something goes just a little bit wrong, and we go, oh, that's it then. We knew that they didn't really have mental capacity. You know, sometimes people learn by their mistakes. I'm not talking about huge mistakes. I'm not talking about financial abuse. I'm talking about maybe spending up before the end of the week, because we haven't quite yet got the hang of managing that money. And of course, avoiding risk aversion, you know, not being, oh, you know, if we conclude they have capacity, then they might spend all that money on such a thing. You know, it's just checking yourself. Is this really just risk averse decision making? In terms of completing a deputyship, you've probably all kind of heard of the COP3. Court of Protection is what the COP bit stands for. This form actually has recently been improved. It's been updated and amended. I have to say I haven't looked at one since, but I've seen people online saying how much better it is. But it can be completed by a number of people. So it can be a medical person, so the GP of the person, a psychiatrist, should you be so lucky as to get a psychiatrist to fill one in, an approved mental health professional, a social worker, psychologist, a nurse, or an occupational therapist. So it's that range of professionals who can complete a document around the assessment of capacity. Again, I'd just give a little rider about being careful of solicitors and what people might charge for these things. Okay, so how do you check? How do you check whether there is an LPA, what that LPA is about, and so on? So I've put there various ways that you can check. So you can check on .gov.uk. I feel like I'm doing an advert for .gov.uk today. You can view a summary of the LPA. You can check whether it's valid. You can check who the attorneys are. To do that using that format, you will need to do that in conjunction with the donor or the attorney. So they will need to be involved in that process of checking online. There are other methods. You can apply to search the register to find out if someone is an attorney or if they are a deputy. Obviously, your first point of call is to ask the person, and they should have no issue whatsoever in showing you their documents. So I'm a appointee for my daughter. I have LPA for my dad. and I'm also a deputy for my daughter for health and welfare. I would have no issue giving evidence of that to anybody. I can't see why anybody would, but if I'm not disputing that they do, I know all too well that sometimes people are not quite as straightforward or as forthcoming as you might like. So you can contact them. Again, this is an online part of the .gov.uk website where you can apply to search the register. You can also raise concerns. So what if there is an LPA or a deputy and they're not acting in the person's best interests? And we do, sadly, we do encounter this quite often. So you can raise a concern with the safeguarding team there, and they will take that up. So you can report your concern there. I think let's just check the next slide. So you can either use the concern raising form, you can write, email or call them. I personally would recommend using the form. You need to give details of the donor, name, address, date of birth, the date you noticed your concern, any evidence you have to support that. Oh, excuse me. What you know about the donor's mental capacity, if you've got any copies of reports. If you don't have all of that, you can still report the concern, and you can gather the information, or obviously they will check whether they've got the authority to investigate. That's their contact details. Sorry. We are getting to the end of the talking bit. I'm glad to say, and I'm going to grab a drink. I might have to do that now, actually. Okay, so these are two documents that I recommend around financial decision making. They're actually both quite old. They haven't been updated for quite a while. I don't know why, but I've put on there also some YouTube videos about making an LPA, introduction, a Mental Capacity Act video on next of kin, which dispels those myths that next of kin can make these decisions, and then a variety of other things. Additionally, there's a little video by Alex Rutkeen on his website about the MCA and money, which I will add to the September newsletter that I'm about to do. So I think that's the end of me speaking. I hope that that was clear. We will discuss in questions where it all gets a little bit complicated, and I hope you've got lots of examples to talk about, because that brings to life really what, like I said, it's inevitably quite a dry subject, but I've tried to give you the full width there of capacity is the dividing line. This side of capacity, you make an LPA while you can make your views known. Do it now, do it today. And the other side of mental capacity, other people will and may act for you, either in your best interest or because they're appointed by the court. But it's much better to be able to choose who you want to do that. Okay, so I think I will end there, and Karen can press the stop recording. Thank you all.
Thanks, Lorraine, on behalf of Shropshire Partners in Care, for giving us the information today about lasting powers of attorney and court-appointed deputies and everything in between. And we're now going to stop the recording so we can have some questions.